Good morning, good afternoon, and good evening to all participants. My name is Thomas Joshua, and I'm an Associate Legal Officer at UNCITRAL. I would like to thank you for your attention and would like to give the floor now to Mr. Jose Angelo Faria, Principal Legal Officer and Head of the Legislative Branch of the International Trade Law Division. Thank you very much.
Good afternoon, good evening, good morning, all participants. It is a privilege to welcome you to this webinar. And now we will have the opening remarks by Mr. Ye, Deputy Director from MOFCOM, and the Secretary of UNCITRAL, Madame Anna Schubambret. Mr. Ye, please, you have the floor.
Thank you very much.
很抱歉，一开始我的设备可能出了点问题，没有听到前面的声音。尊敬的安娜秘书长，尊敬的安吉勒先生，各位专家，大家上午好。
Sorry for the inconvenience. There are some technical issues on our side, but anyway, Secretary Anna Schubambret, Mr. Angelo, your experts, good morning and good afternoon.
很高兴参加联合国贸法会主办的本次专家会。 通过视频方式与大家共同探讨可转让电子运输单证相关问题。感谢秘书处为筹办本次会议做出的辛勤努力，也感谢各位专家对解决铁路运单物权凭证问题的持续关注和大力支持。
It gives me great pleasure to attend this expert meeting hosted by UNCITRAL. Here we will discuss with all of you the issue of transferable electronic transport documents. I would like to thank the Secretariat for your preparation of this meeting. I would like to also thank all the experts for the commitment and support on the issue of railway consignment notes as documents of title.
首先，请允许我介绍一下中方参会人员，他们是国家铁路局国际联运所所长崔艳萍女士。
First, please allow me to introduce to you the Chinese experts participating in today's meeting. They are Ms. Cui Yanping, Director of the International Multimodal Institute of the National Railway Administration.
国家铁路局综合司外事司庞淑娟、沈淑贤女士。
Ms. Pang Shujuan and Ms. Shen Shuxian from the Comprehensive Department of the National Railway Administration.
招商局能源运输股份有限公司副总经理兼总法律顾问，国际货代协会联合会法律事务咨询委员会主席杨运涛先生。
Mr. Yang Yuntao, Vice President and General Counsel of China Merchant Energy Shipping and Chairman of the Advisory Body of Legal Matters at FIATA.
招商局集团交通物流事业部供应链部业务总监王宁女士。
Ms. Wang Ning, Business Director of the Supply Chain Department of Transportation and Logistics Business Unit of China Merchant Group.
招商局集团交通物流事业部风险管理中心法律顾问宋安琪女士。
Ms. Song Anqi, Corporate Counsel of the Legal Department of Transportation and Logistics Business Unit of China Merchant Group.
北京大学海上法研究中心主任郭瑜女士。
Ms. Guo Yu, Director of Maritime Law Research Center of Beijing University.
中国银行江苏分行交易银行部副总经理、国际商会银行委员会执委会主席许军女士。
Ms. Xu Jun, Deputy General Manager of the Global Transaction Banking Department of Bank of China Jiangsu Branch and member of ICC Banking Commission Executive Committee.
中国工商银行卢森堡分行营业部国际业务产品经理肖倩女士。
And Ms. Xiao Qian, the International Business Manager of the ICBC Luxembourg Branch Banking Department.
为适应国际铁路运输迅速发展并成为国际贸易重要运输方式的新情况，为解决中小企业在铁路运输中引入可转让单证的现实需求，促进国际陆上贸易发展，助力全球经济增长，中国政府于2019年7月在联合国贸法会第52届年会上提交了提案。提案建议将解决铁路运输单证物权凭证问题纳入贸法会工作方案，并就起草有关法律文书开展研究工作。在各方的大力支持下，中方的提案在贸法会第52届年会上获得通过。
To accommodate the new situation that international railway transport is growing rapidly and is becoming a key means of transport in international trade, to address the real demand of medium and small-sized enterprises of introducing transferable documents in railway transport to boost international land trade and to underpin global economic growth, the Chinese government submitted to the UNCITRAL 52nd session a proposal in July 2019. The proposal recommended that UNCITRAL include in its work program the issue of RCNs as documents of title and start researches on drafting relevant instruments. With the great support of all parties, China's proposal was adopted at the UNCITRAL 52nd session.
此后，根据委员会的授权，秘书处在安娜秘书长的领导下，开展了大量卓有成效的探索工作，并多次召开专家会，研究起草关于可转让多式联运单证的国际法律文书。
Following that, mandated by the UNCITRAL, the Secretariat, led by Secretary Anna, conducted a massive amount of productive explorations. The Secretariat also have held multiple expert meetings on drafting international instruments for transferable multimodal documents.
在这个过程中，电子运输单证始终是一项重点关注和研究的内容。在2019年12月举办的第一次专家会上，安吉勒先生在发言中就曾提出电子运输单证及其证据功能、可转让功能等问题。
In this process, electronic transport documents has always been a focus of the research. At the first expert meeting in December 2019, Mr. Angelo already mentioned electronic transport documents and such features of such documents as evidential value and negotiability.
随着电子数据交换、区块链等技术的发展和应用，无纸化贸易方式日渐兴起，与之相关的金融、运输、通关、报检等领域电子化进程也不断推进。电子运输单证已经成为未来国际贸易物流的发展方向。
With the development and adoption of such technologies as electronic data interchange and blockchains, paperless trade is becoming a trend. Relevant electronic applications such as in areas such as financing, transport, customs clearance, and inspection is getting more and more prevalent. This makes electronic documents a future trend for global international trade and logistics.
贸发会秘书处筹办的这次会议聚焦电子单证领域的规则及实践，研究新国际文书起草过程中涉及的相关问题，这将确保新国际文书适应当前电子化的发展趋势，具有十分重要的现实意义。
At this UNCITRAL expert meeting, we will focus on the rules and practices of electronic documents and look into relevant issues regarding the drafting of new international instruments. This will make sure that the new international instruments will keep up to the trend of the dematerialization of documents, and thus making this meeting ever more relevant.
事实上，联合国贸法会秘书处已经在电子单证领域开展了大量的工作。贸发会先后制定了电子商务示范法、电子签名示范法、电子可转让记录示范法等重要的国际文书。此外，贸法会制定的汉堡规则第14条第3款也涉及电子提单的使用问题。此后制定的鹿特丹规则专章规定了电子运输记录，以国际公约形式确立了电子单证适用的法律框架。这些既有的重要成果，充分体现了贸法会在国际规则制定领域的立法前瞻性，也为可转让多式联运单证新国际文书的相关规则起草提供了有益的指引。
As a matter of fact, the UNCITRAL Secretariat has already conducted a lot of work in this area. For instance, UNCITRAL formulated and published the model laws on electronic commerce, electronic signatures, and electronic transferable records. Besides, paragraph 3 of Article 14 of the Hamburg Rule mentioned the usage of electronic bills of lading. The Rotterdam Rules dedicated a chapter for electronic transport records. This international treaty establishes a legal framework for the application of electronic documents. These important outcomes demonstrates the forward thinking of UNCITRAL in formulating international rules. It also provides helpful guidance for drafting relevant rules under new international instruments for negotiable multimodal bills of lading.
为推动解决铁路运单物权凭证问题，秘书处已经开展了大量的工作，付出了辛勤的努力。我借这个机会向秘书处表示衷心的感谢，同时也感谢各位专家参与本次会议，为我们解决这个问题建言献策。
To address the issue of RCNs as documents of title, the Secretariat has done a lot of work. So taking this opportunity, I would like to express my thanks to the Secretariat. I would like to also thank our experts for participating in this meeting, and I look forward to your viewpoints.
我们愿意通过本次会议，与各位专家深入研究探讨电子单证的规则及实践，理清思路和方向，为做好新国际文书的起草工作奠定良好的基础，做出我们的贡献。
We hope that at this meeting, we will be able to clarify our thinking and find the right direction and lay a sound foundation for the drafting of the new international instrument.
最后，预祝我们的研讨会成功，谢谢大家。
Finally, I wish this webinar a full success. Thank you very much.
Thank you very much, Mr. Ye, for your greetings and kind words. And be assured of our appreciation for your support that you and your colleagues at Mlvtr have extended to this project all along. Now, it's my pleasure to give the floor to Madame Mlvtr.
Thank you very much, dear Director General Ye, distinguished experts and participants. A warm welcome from Vienna. My name is Anna Joubin-Brett. I'm the Secretary of UNCITRAL, the United Nations Commission on International Trade Law. It's a great pleasure and honor for me to open this webinar and to welcome you all for these 2 days of discussions. The webinar is organized by the UNCITRAL Secretariat jointly with the Ministry of Commerce of China, MOFCOM. Since November 2019, MOFCOM and the UNCITRAL Secretariat have entered into a memorandum of understanding that has already resulted in deepening our cooperation on international trade law in many different areas. One of the important aspects of this MOU is the exploration and preparation by the Secretariat of legal solutions for the development of negotiable multimodal transport documents. That mandate originates in the proposal by China to UNCITRAL in 2019 to undertake work on an international legal instrument that would provide for international legal recognition of a negotiable railway consignment note, acknowledging that contractual solutions alone do not ensure adequate certainty and predictability in the documentary credit transactions and do not respond to the expectations of trade finance, banks, and institutions. During the exploratory phase of this project, it was found that restricting the focus to railway consignment notes would address the issue only in part, and that it was advisable to explore and prepare multimodal responses. The project is now looking at developing negotiable multimodal transport documents, taking into account interoperability and multimodal aspects to the forefront. It would not be the first time UNCITRAL texts address these two characteristics, interoperability and multimodality. UNCITRAL has already dealt with the legal issues of unimodal plus transport, including with its Rotterdam rules, adopted in 2008, that address negotiable transport documents in the C+ context. At the same time, other organizations have been looking into a negotiable transport document in the Railway+ context, but so far, no harmonized and interoperable solutions have emerged. With the development of large railway infrastructure projects in several regions, but mostly pushed by the development of the Asia to Europe and Europe to Asia context, the multimodal aspect added to railway negotiable transport documents have become more relevant, including where no sea leg is included. The subject is complex and delicate as it touches upon interests of several industries and interests: banking, transport, insurance, customs. Mr. Ye has very aptly listed those stakeholders involved, as well as regional organizations already dealing with one or the other aspects of transport, logistics, and liability regimes, and having developed their own standards over the years. And this is one of the biggest challenges in this project: how to decouple negotiable transport documents from the liability regime, which is quite fragmented, especially in the multimodal transport context. The approach we are suggesting, and that you will be discussing in the 2 days to come, is to take a so-called dual track approach by providing for a negotiable document that would coexist with a transport document already in use in different modes of transport, such as railway consignment notes, airway bills, or others. Many open issues remain, in particular, if that approach were to be followed, how to put in place an appropriate interface between a new instrument on a negotiable transport document and existing legal and liability regimes applicable to different modes of transport. Another aspect that needs to be addressed, and where UNCITRAL has also a strong experience, as Mr. Ye reminded us, is the dematerialization of negotiable transport documents into electronic and digital documents. UNCITRAL's e-commerce texts are all about electronic signatures, electronically transferable records, and paperless trade. In this day and age, you would think that international trade, logistics, and finance would be at the forefront of paperless transport and trade documents. But quite surprisingly, the transport and the trade finance industry have been quite conservative in this regard. The COVID-19 pandemic has shown us how vital it is to achieve the transition into paperless trade. The development and negotiation of multimodal transport documents will fully benefit from this well-developed legal framework based on UNCITRAL principles of technology neutrality, functional equivalence, and the use of electronic records, as well as concepts of uniqueness or singularity and possession or control already developed in the UNCITRAL transport framework. This webinar will assess experience with the use of those provisions in practice, which will help in a future work by UNCITRAL on electronic negotiable multimodal transport documents. We believe that if properly addressed, it can unleash the potential of international trade, including by facilitating access for small companies, for small traders, for MSMEs to trade finance in the context of foreign trade transactions involving carriage of goods by means other than ocean carriage. We would, of course, have preferred an in-person interaction with all of you in an UNCITRAL colloquium such as the ones we are used to when a new subject is being explored by the UNCITRAL Secretariat. But under the current circumstances, for more than a year now, webinars have become our main means of reaching out to the legal community and seeking views and inputs of legal practitioners on commercial law issues. I therefore look forward to fruitful discussions, albeit online, and useful inputs for the Secretariat when setting out the policy options for digitalization of negotiable multimodal documents for consideration by UNCITRAL at its next session. I thank you all for your attention and for finding time to participate and contribute. Thank you very much. Best of luck for the 2 days.
Thank you very much, Madam Secretary Anna Juban-Brett. Thank you very much, Director General Ye. And now, without further ado, we then move to our first panel. We'll have 2 panels every day, and each of the 2 days, and we'll have a short break of 15 minutes between each one of them. As you see, the program is structured beginning from the general legal framework, as in the first panel. The second panel would look at practice in particular and the needs in particular in the banking sector, and tomorrow will be devoted exclusively to the use of electronic transport documents in different transportation modes, beginning with those areas where transport documents are not negotiable, and then the closing panel with the use of electronic transport documents in the maritime sector. Now, for the first panel, we have 3 speakers. Each of them would have around 15 minutes to make their presentations, and I'll introduce the 3 of them. Now, you have your biographies in the program, but very briefly, the first speaker is Kawei Chong. He's a senior legislative drafter in the legislation division of the Attorney General's Chambers of Singapore, has been in that division since 2006, and before that in different positions in the judiciary. He's very well known in the world of international harmonization of commercial law, in particular electronic commerce, as a delegate of Singapore to UNCITRAL Working Group 4 on electronic commerce, and he has been the head of that delegation since 2012. Kawei will address us on the experience in Singapore on consideration of the issues addressed in the model law on electronic transport records and its scope for enactment in Singapore. The second speaker is Professor Yu Guo. She is an associate professor and director of the Maritime Law Research Center at the Beijing University. She has a master's degree from Shanghai Maritime University, a PhD from Beijing University, and an LLM from Cambridge. She has joined the Faculty of Law School of the Virginia University, and she has been teaching there since 1996. Yu Guo will address the perspective of China on the UNCITRAL model law on electronic transfer records. And last but not least, we have Dr. Alan Davidson, who is a solicitor and barrister at the Supreme Court of New South Wales in the High Court of Australia, and still practices as a consultant, has been a member of the law faculty of University of Queensland for 24 years now. He has been attending UNCITRAL sessions as delegate of Australia in Working Group 4 since 2014. And Alan would address us on the relationship between the model law on electronic transferable records and documentary credits, focusing on letters of credit. Now, I'll give then the floor to Kawei. Kawei, please.
Thank you, Angelo. Okay, let me try sharing my screen. Firstly, I'd like to thank the UNCITRAL Secretariat for inviting me to share some information and views and knowledge on the subject of the model law on electronic transferable records, Mlvtr, which Singapore had very recently enacted in our electronic transferable records. Let's go straight away. Okay, so I will first speak a bit about electronic transferable records as an introduction. Then I'll spend most of my time speaking about the Mlvtr as adopted in Singapore. And then I'll spend a few minutes talking about the Multimodal Transport Act, which was recently introduced in Singapore, which is not in force yet. Okay, firstly, let's look at this category of documents. In the Mlvtr, we have this shorthand term transferable documents or instruments that was used to describe this category of documents. There are quite different instruments, but they all have a similar set of characteristics. So for our purposes today, it is the bills of lading that is of interest to us, an instrument that entitles the holder to delivery of goods. Right? So the common characteristics of these documents, the rightful possession of the original of the document confers the holder with the rights represented by the document. And the second characteristic is that it's possible to transfer that document by transferring the document to transfer all the rights represented by the document. That's why we refer to it as transferable documents or instruments, right? And there was a problem with electronization. In the electronic environment, if you create an electronic copy of an electronic record, the copy is identical with the original. And so there isn't really a uniqueness in the electronic world of the original, right? And if the electronic records, when replicated, could give rise to multiple claims based on those records, this is a situation that is hugely problematic, and therefore the use of ETRs will require special legal rules that would recognize the electronic equivalent of the paper-based original, right, and its use. Okay, so the Mlvtr was enacted into the Singapore Electronic Transactions Act, which was introduced to Parliament earlier this year and came into force relatively recently on the 19th of March, 2021. Firstly, an introduction to the approach taken in the Mlvtr. So like many UNCITRAL e-commerce texts, this instrument adopts certain principles. Firstly, the principle of functional equivalence, which is illustrated in Article 1.2, where essentially it says that the substantive law governing the transferable document or instrument is not affected, right? The second principle is technology neutrality. So in the provisions, it tries to be as technology neutral as possible. And thirdly, non-discrimination, which is that an ETR should not be denied legal effect solely on the ground that it's electronic, right? To treat the electronic form as of equivalent status as the physical form. Okay. So having looked briefly at the problem of electronization, so what is needed in the text is that the two most important things, there needs to be a functional equivalent of the unique original paper instrument, and there needs to be a functional equivalent of what is possession, right, of the instrument. And if this text provides all the sufficient rules, it will enable the electronic transferable record to be legally equivalent to the paper-based instrument, and in that way will be effective against third parties. So we have here on screen, I've reproduced two definitions. One is the definition of electronic transferable records. You see that it refers to Article 10. Article 10 is the functional equivalence rule for a transferable document instrument. We'll be looking at that shortly. I've also reproduced the definition of transferable document or instrument. The main thing to note here about this definition is that it is a qualitative definition. Means a document or instrument issued on paper that entitles the holder to claim, performance, etc., and to transfer the right through a transfer of that document instrument. Therefore, any document or instrument that satisfies this description would be a transferable document or instrument. So in Singapore's ETA, when we enacted this definition, we provided some illustrations of what a transferable document instrument could be. or are bill of lading, a promissory note, etc. But this is not a closed list. Any document instrument that satisfies this would be a transferable document instrument. Okay, so this is section 16H, which enacted Article 10. This is a functional equivalence rule for the electronic equivalent of a transferable document instrument. So on the one part in paragraph A, that electronic record obviously ought to contain all the information that should be contained in the paper document. Right? And secondly, a reliable method, which basically means the system, is used to identify which electronic record is the one that matters, right? Because we contemplate there will be many electronic copies of that electronic record, but only one can matter, which thereby ensures that there's only one claim. Right? Okay, in Roman 2 and Roman 3, it also states that that record must be capable of being subject to control during its entire life cycle, and thirdly, to retain integrity. Now here in paragraph 2, the criterion for assessing integrity is whether the information, including any authorized change, remain complete and unaltered. Now this is an interesting inclusion here, which we didn't see in earlier UNCITRAL texts. This is the what basically this is saying is that an electronic transferable record is dynamic in nature. We can understand this quite easily by noting that if a person adds an endorsement to an instrument, a bill of lading, promissory, a bill of exchange, then the information in that instrument has just changed, but it is still the same instrument. So this is what section 16H here, subsection 2 is talking about. Section 16I enacted Article 11. This is the other key functional equivalence rule, which says that possession is the electronic functional equivalent of, rather, control is the electronic functional equivalent of possession. The point to note here is that the control that is required by this provision is exclusive control. Right? That's the first point. But the second is that there is a need for the method to identify the person who is in control. And one point to note here is that the word identify does not necessarily mean to know the name of the person in control. So this particular provision was contemplated to allow for bearer instruments also to be covered. Right? Okay, in subsection 2, here we have the functional equivalent of transfer of possession. So transfer of control is the electronic functional equivalent of transfer of possession. And this is important, obviously, for the concept of delivery, which is achieved through transfer of possession. Okay. We have in section 16K, which enacted Article 15, a functional equivalence rule for endorsement. This is a very all-encompassing provision that covers all forms of endorsement. Right? Okay. And we also have in section 16L, the functional equivalence rule for amendment. Right? I think what we just need to know is that the model law has covered all these areas for which a functional equivalence rule was found to be necessary, and it's all there in the model law. Right. Okay, section 16O enacted Article 12. This article is referred to as a general reliability standard. So you have noticed that in most of the functional equivalence rules that we looked at earlier, there is a reference to a reliable method. So reliability is a relative concept. It's not an absolute level of reliability. So what is a reliable method is this particular provision here supplies some criteria for assessing it. It is as reliable as appropriate, taking into account all relevant circumstances, which may include this whole list of factors. Okay, and there is in 1601B what provision which we call the safety clause as a shorthand, proven in fact to have fulfilled the function by itself or together with any further evidence. This is to enable a particular method to be found to have satisfied the functional equivalence rule, even if there's a theoretical challenge on reliability, if it's shown to have fulfilled the function. Right. So here, section 16.0, Article 12, illustrates the tension between the desire for certainty and for technology neutrality. So for UNCITRAL text, we always want it to be as technology neutral as possible. So Article 12 and all the functional equivalence rules refer to relative notions of reliability, but there is still some need for, especially for users, a desire for certainty. And so here in 1601B, the safety clause provides some certainty. Right? Here, section 16.0 subsection 2. Here in Singapore's ETA, we included a new provision. This is not in the model law. We include a provision that says that if there are any legal proceedings involving an ETR that was issued, transferred, controlled, presented, essentially managed by an accredited ETR's management system, which is provided by a provider that is either registered, licensed, accredited, or recognized according to laws that have yet to be made, then it is presumed that the methods concerned are as reliable as appropriate. So this gives an evidentiary advantage to users of an ETR if the ETR is being supported by a provider whose system has been vetted, essentially by an authority that does the registration, licensing, accreditation, or recognition. Okay, these are a couple of other topics that the Mlvtr covers, the change of medium. I won't go into them due to lack of time. There's also a provision on non-discrimination of foreign ETRs. Okay, just spend a couple of minutes on this. Okay. In 2005, in ASEAN, there was a framework agreement on multimodal transport that was concluded, and Singapore enacted, gave effect to that treaty through the Multimodal Transport Act that was introduced earlier this year. I'll just look into a few definitions and draw the connection with the Mlvtr shortly. Okay, so firstly, the multimodal transport document covered by this act refers to international modal transport of goods. That's one. Okay, this is the definition of multimodal transport contract. Essentially, the most important thing is about international multimodal transport of goods. Okay, now the definition of international multimodal transport says it means carriage of goods on the basis of a multimodal transport contract by at least two different modes of transport. Right, so it sets the threshold as two, and the modes of transport is defined to mean transport by road, rail, inland waterways, sea or air. And any two of these modes of transport would make this a multimodal transport contract. And if it is international, then it would be a contract that comes under the scope of this act. Okay, Section 9 talks about issue of a multimodal transport document. Section 9.2 states that at the option of the consignor, the multimodal transport document must either be in negotiable or non-negotiable form. Right? And Section 9.4 and 5 contain additional provisions describing how the negotiation takes place. But the key point here that I wanted to share is that the provision explicitly recognizes that the multimodal transport document can be negotiable, right? And as I pointed out earlier, the definition of a transferable document or instrument in the Mlvtr is a qualitative one. As long as the negotiable multimodal transport document fulfills the definition of a transferable document instrument, it would be covered by the Mlvtr and as enacted by in the Singapore ETA. Okay, these are my last two slides. Just to point out, in Section 11, this is an evidentiary provision which we need not spend too much time on understanding. What I just want to point out is that it refers to electronic data interchange, which indicates that the drafters of this particular treaty contemplated that the multimodal transport document could be in electronic form, right? So there was some consciousness of the possibility of electronic form. Okay, and this is the definition of EDI, a very general, rather general definition, but yeah, it does not. This act itself does not describe how the multimodal transport document is to be electronized. But I would think that the Mlvtr, as enacted in Singapore ETA, would be able to do the job, assuming that the negotiable multimodal transport document fulfills the definition of transferable document instrument. Okay, this is all I have. And thank you for your attention. I'll hand the floor back to Angelo.
Thank you very much, Kawei, for this very comprehensive and interesting presentation, and congratulations on the entering into effect of your enactment of the model law. Now we move to our next speaker. That's Professor Yu Guo. Professor Guo, you have the floor.
Can you hear me?
Yes.
Hello. Hello.
Yes,
okay. Okay. Good morning and good afternoon. I'm very honored to have this opportunity to share with you some of my views on the Mlvtr and the new instrument proposed by Chinese government. I will focus on 3 points. That is the relationship between the Mlvtr and China, inspirations of the Mlvtr, and a suggested legal framework for transferable transport document. China is a member of UNCITRAL, and it has participated in the negotiation of the Mlvtr from beginning to end. China believes that ETRs will promote economic development, but also has a concern that the replacement of paper-based document by electronic record may threaten the stability of market order. So most proposals of Chinese delegation in the negotiation of the Mlvtr focused on the issue how to keep the balance between enabling the new technology and keeping the market order and financial security. It is believed that the key issue to keep the balance is to ensure that the principle of functional equivalence is strictly followed. That is, electronic records shall be given the same legal status as a paper-based transferable document if and only if it can perform the same functions as a letter. In the end, a so-called singularity approach had been adopted, and it is believed that this approach can ensure the functional equivalence between paper-based document and its digital counterpart. China hasn't adopted the Mlvtr yet. However, since the business practice of electronic bill of exchange and electronic bill of lading are developing quickly, it is generally believed that legislation on ETRs will be made sooner or later, and the study of the Mlvtr will be a good starting point to make the domestic law. Now I will move to my second point, inspirations from the Mlvtr. Currently, China is proposing to draft a new international instrument on non-ocean bill of lading, that is, bill of lading used in transportation modes other than ocean transportation. In my view, the proposed new instrument and the Mlvtr have some similarities and connections, because both instruments are dealing with the creation of a new transferable document. And we can get some inspirations from the Mlvtr to help the drafting of the new instrument. The first inspiration is related to the principle of non-discrimination. It was insisted in the drafting of the Mlvtr that if the electronic record can perform the same function of a paper-based transferable document, then it shall be given the same legal status. Come to the situation of ocean bill of lading and non-ocean bill of lading. Both documents are transport documents, but only ocean bill of lading is recognized as a document of title. However, ocean bill of lading is not a document of title the first day it was born. It acquired this function because there was a requirement in business to use it as a document of title, and the practice was gradually formed and then recognized by law as a custom. Bill of lading as document of title was not used in other modes of transportation, not because it was prohibited by law, but just because there was no such requirement. Because in the past, modes other than ocean transportation were rarely used for international trade, and so there was no requirement for document of title. But now the other modes are used more frequently in international carriage of goods. If a document can be used to support the finance in ocean carriage, but not in other modes of transportation, the other modes of transportation will be less attractive. So this is just a simple question of fairness. What happened in China-Europe Railway Express has showed that there is a true requirement for document that can be used as bill of lading in railway transportation. If there is a reliable method to ensure the document used in railway transportation performs the same function as ocean bill of lading, there is no reason why the same legal status cannot be given to such document. And this leads us to the second inspiration, the principle of functional equivalence. Functional equivalence is a precondition of non-discrimination. Non-ocean bills of lading shall be given the same legal status if and only if they can perform the same functions as ocean bill of lading. The most important function of the ocean bill of lading is to be a document of title. It can perform such a function not because there is anything magical about ocean carriage, but just because there is a whole system in maritime law to ensure that the title of the cargo can be logged into the document. And so only the holder of the document can control the disposal of the cargo itself. In this way, the document can represent the cargo and can transfer the title to the cargo. It is not easy to create such a system in other modes of transportation, but it is not impossible. In the negotiation of the Mlvtr, a long time has been spent to find a functional equivalence rule for ETRs. It may also take a long time to find a functional equivalence rule for non-ocean bill of lading, and a lot of creativity will be needed. The third inspiration is about the enabling legislation. There are different opinions on the necessity to draw a new instrument on non-ocean bill of lading. One argument is that if the parties need a non-ocean bill of lading, they can do it by themselves. The same argument had been made at the beginning of the drafting of the Mlvtr, but a consensus was achieved that a transferable document cannot be created by contract because the nature of transferability may affect the right of third parties, and in particularly may conflict the principle of numerous clauses. I guess this is true also for non-bill of lading. And of course, we have another option. We can wait till the business practice becomes a custom, but this will take a long time and will leave the rights and obligations of the parties in a state of uncertainty. To draft a new law to enable the use of the non-ocean bill of lading will help the industry a lot. So if creation of a non-ocean bill of lading is not impossible, how shall we do it? Currently, many scholars are working hard and trying to find a proper way, and here are some of my personal suggestions. Firstly, I suggest that we use the concept of transferable transport document instead of non-ocean bill of lading. Since if non-ocean bill of lading can be used as document of title, then there will be no difference between ocean bill of lading and non-ocean bill of lading, and they can all be called transferable transport document. And the concept of transferable document instead of bill of lading is used in the Mlvtr. So the use of the new concept will be in line with the Mlvtr and will avoid the confusing problem of what is a bill of lading or what is a document of title. And the transferable transport document will have the same function as the traditional ocean bill of lading. That is, it can represent a cargo and can be used as collateral in international trade. Secondly, I suggest that the new instrument sets out the conditions that a transferable transport document must meet without referring to the modes of transport. For example, it can be provided that a transferable transport document can be issued for cargo in transit. The document can be issued only by the person who has actual control of the goods in transit, and the issuer shall dispose of the cargo in accordance with the order of the holder of such document. In this way, we can create a document which has the function of the traditional ocean bill of lading, but is model neutral. An instrument drafted in this way will have several advantages. Firstly, to issue a transferable transport document will be a right instead of an obligation. A carrier or multimodal transport operator is not forced to issue such a document, but he is entitled to do so if he can meet the legal requirements. It is just like to give him an option to provide a kind of additional service to his customers. Secondly, the change of any existing law will not be a precondition. The new instrument just makes it clear that it is possible to use a transferable transport document like bill of lading in non-ocean transportation, but there are minimum requirements that have to be met. It will give different modes of transportation a fair competition opportunity in international trade. But whether and how to take this opportunity will be left to different modes of transportation. And certainly, the new instrument can also help the implementation of the Mlvtr. Since the Mlvtr applies to transferable documents, but it does not provide how a document can be recognized as a transferable document, and this can be completed by the new instrument. In this way, the new instrument and the Mlvtr will together create a mode neutral and a media and technological neutral legal framework for a transport document, which is freely transferable and can be used as collateral in international trade. Of course, there will be difficulties. For example, one common concern is whether it is possible to create a transferable transport document while the liabilities of carriers on the different transport modes are different. This worry can be relieved by the fact that there are different liability systems for ocean carriage, and this does not affect the use of ocean bill of lading as document of title. I guess this is a good evidence that the unification of the law of transferable transport document is not necessarily dependent on the unification of the laws of transport liability. There is a saying that document of title is no longer important in international trade, since the banks are relying less and less on document of title, but rely more on credit of the parties. The answer to this is that although the banks can rely on the credit of the parties, there are advantages to rely on the document of title to finance the international trade, especially for supply chain finance. One important concept of international supply chain is the separation of the flow of actual cargo and flow of document of title. Serving as document of title, bills of lading can provide a safe means by which banks can finance the international shipping of goods. In short, in my opinion, there are some similarities and connections between the Mlvtr and the new instrument proposed by Chinese government. It is suggested to establish a legal framework for mode mutual and technological mutual transferable transport document. I believe such a legal framework will help the international trade, especially supply chain finance. Of course, these are just preliminary ideas and need to be developed, and your comments and suggestions will be warmly welcome. Thank you.
Thank you very much, Professor Guo, also for setting the stage for so many aspects of our discussion in the course of the next 2 days. Thank you very much for that. So now we move to the third and last speaker of this panel. Alan, would you please take the floor?
Good evening. Can I first confirm that you can see my slides and that you can hear me?
Yes, we can hear you and see your slides. Thank you.
Excellent. Thank you. Thank you very much. Madam Secretary, colleagues, distinguished guests, thank you for the invitation to speak. Indeed, my first association with UNCITRAL was when I was invited in 2011 to speak on electronic letters of credit when they wanted to start up the Working Group 4 again for the purposes of the model law of electronic transferable records. And here I am more than 10 years later, still speaking about electronic letters of credit. I thank Professor James Byrne, who encouraged my speaking at that session in February 2011. So I'm looking at the question of banking and letters of credit and the documents that are used in international trade and the electronification, if that's a word that we can use, in banking. Firstly, I will say banks have embraced electronic commerce. Compared to 19th century banking with lots of papers, pieces of papers and clerks, banks, when electronic commerce came on, have embraced the technology, used the technology and created great efficiencies. Banking in the 21st century is very different to the 19th century. In 1974, they formed the SWIFT, the Society for Worldwide Interbank Financial Telecommunications. Really, it was nothing more or less than the bank recognizing that communications could be made internationally between banks much more efficiently and much more positively. The SWIFT is really nothing more or less than the bank's own private internet before the internet existed. And they used it and there are great efficiencies. Today, transactions occur not in the billions of dollars, but indeed the trillions of dollars, if I may refer to dollars. SWIFT has 1,000 employees, is based in Belgium, and is comprised of about 1,100 financial institutions and banks for the purposes of facilitating speedy communications using electronic commerce. Banks have certainly done that and embraced that. Personal banking and merchant banking and all forms of banking is largely electronic. It's a very different system from when I was a youth, when everybody was paid in cash and cash had to come out of the banking system. People would be paid in cash and it would go often back into the banking system. Now on payday, we typically have banks paying each other. So the employers pay all the employees and banks are paid instantly. And there is massive efficiencies which banks have in relation to how they structure money, how they invest money, and how they use that money. Payment systems are much more electronic. In the 1970s, there were the two main payment systems were cash and checks. well, we still use cash, but less so, and particularly during the COVID time, we seem to be using less cash, and checks have slowly been diminishing. And the number of electronic systems that have come up because of the opportunities that merchants have taken and bankers have taken is quite phenomenal. Not to mention things like cryptocurrency, Bitcoin, and so forth. So that's my one slide on banking. I want to get into letters of credit, because ultimately letters of credit are used in international trade law extensively, in the trillions of dollars per year. And I've got some statistics which I'll show you in a moment. But I will talk about commercial letters of credit, because there are several types of letters of credit. And we're talking about commercial letters of credit where it is used as a payment system in international trade. We will see that banks deal in documents. They're not really interested in the underlying contracts. They're not really that interested in the goods or services to which underlying contracts relate. Banks want to look at and examine documents like a bill of lading, like a commercial invoice, like a railway consignment, whatever is required for a particular transaction. And if those documents are in order, they will hand over $2 million. And the question becomes, can those documents be electronic? And they are electronic, and they can be electronic. And what we need in place is certainty about the laws about electronic documents. Now, the model law of electronic commerce was a good first step, a great first step, and the model law of electronic signatures and the Electronic Communications Convention. I would like to thank Carl Way, by the way, for giving a good explanation, I think, of what is the model law of electronic transferable records and how it's been implemented in Singapore. I found that most fascinating. I also was most interested to hear of the proposal for a transferable transport document by China. But let me get back to this. Banks are being used as intermediaries because there is, after all, risk in international trade. There is risk in law commerce. Do I trust the buyer's going to pay? Do I trust the seller's going to send the documents? So we use the banks as an intermediary because we trust them. Two key words in international trade: trust and risk. And we trust them, particularly there are first-class banks we really trust, and maybe there are some other banks in some countries we don't. But ultimately, banks have this great reputation that if they receive documents and the documents are in order, they will hand over the amount of money owed, because they have given their word, they have given their obligation, they have given their undertaking. And they're undertaking to say that they will pay on receipt of these documents. If I can use the expression, you can take to the bank. You can rely upon it perhaps more than the law. Indeed, you can rely upon it more than you can rely upon the underlying contract. The English courts have talked about commercial letters of credit as being the lifeblood of international commerce, as being the equivalent of cash in hand. If I give you the right documents, I get paid. Now, of course, if you don't get the right documents because for some reason or other they don't comply, you were late in putting on board the ship and the dates are wrong because something has gone wrong, then the payment mechanism falls down and the seller has to go back to the buyer, and that's riskier. But banks are used. Now, they are referred to as documentary credits. Angelo referred to that in the introduction. Really, there is nothing different between a letter of credit and a documentary credit on the whole. It's meant to be the same thing. But why is it referred to as a documentary credit? Simply for the reason that banks deal in documents in a letter of credit. And sometimes it might be something as simple as a demand, but in international trade, it's often a series of documents which represent various parts of the transaction. The bill of lading, if it's an ocean bill of lading perhaps, or something equivalent, or a commercial invoice. In fact, I have a slide that will tell you that. After all, an irrevocable a letter of credit, a documentary credit, is an irrevocable independent obligation by banks to honour, usually to pay, but to honour on receipt of complying documents. And it's about these documents that the model law of electronic transferable records comes into its own to assist in international trade and to provide some certainty. Now, there is the Uniform Customs and Practice for Documentary Credits that is put out by the International Chamber of Commerce since 1933. The latest edition is the UCP 600, which came out in July 2007, something which I know reasonably well because I was the Australian delegate that got to go to Paris in 2006 on the final discussion about the UCP 600. And they say the ICC states that international bankers in more than 175 countries use these rules in their letters of credit. Professor Boris Gazolchik, many of you might know because he was a delegate for the US for the United Nations Convention on Independent Guarantees and Standby Letters of Credit, a wonderful person, refers to the UCP 600 as a truly universal normative usage. Basically, in commercial letters of credit in international trade, if you don't use the UCP 600, a bank might go, why are you not using the UCP 600? Now, it might be that it's not a commercial letter of credit and you might use other rules, but for commercial letters of credit in international trade, it is truly a standard instrument. The ICC has been very successful in the first word of the title, to unify the uniform of the customs and practice of documentary credits. Because in the 1920s and 30s, letters of credit were a mess. And over the years, over the 70, 80 years, the IC has standardized the rules that applies to it. Now, we do have the ICC, the International Chamber of Commerce, does have the EUCP, which was first issued in 2002, but the latest edition is in 2019. And I kind of don't have time to go into that because it's supposed to talk about electronic presentation and the presentation of electronic documents, but it has a very low uptake by commercial parties. I'm a member of the Institute of International Making Law and Practice, which goes around the world asking bankers and lawyers about what is your practice. And the EUCP has been used very lightly. I've got these figures here. About 11 to 15% of all international trade worldwide uses letters of credit, but it's a greater percentage in the Asian region. Now, there are not hard figures on the usage of letters of credit because they are private instruments. Someone asks for a letter of credit to be issued by a bank, the bank issues it, it's paid to a beneficiary, and it's a private transaction. However, one estimate, and I think it's conservative, is that it's in excess of $6.3 trillion per year. Done by a particular student. This is an example. There are US banks which are required to report to the prudential body on how much they owe under their letter of credit obligation every 3 months. Now these are, and the top bank, Citibank, this is not $79 million, this is $79 billion. All these figures are in the thousands. I don't have the table to say that. The list is actually 400 banks long, but I've only put in the top 40 because you don't want to read all 400 of them. Citibank, Wells Fargo, JP Morgan, Bank of America. But this is only a snapshot of the third quarter of 2020. I don't have the last quarter to show you what is outstanding under net letters of credit. 79 billion, 71 billion, 60 billion. It drops off reasonably quickly because there are some main banks that we deal with. But it doesn't deal with European banks, Asian banks, and other banks. So this is merely because there is an American requirement. It is billions of dollars. And each one of them, each letter of credit that is issued, a letter of credit could be issued for $1 billion, it could be issued for $25,000, something that we would use for international trade or other purposes. So they are substantial instruments, but they deal in documents. Article 5 of the UCP 600, the whole article says, banks deal with documents, not with goods, services, or performances to which the documents may relate. It doesn't matter that if the goods are whether the goods are put on board the ship. It doesn't matter that the ship sinks and the goods are destroyed. If the correct documents are presented to the bank for payment, the bank must pay. Now, presumably, one of those documents might be a certificate of insurance, and the correct party is reimbursed if the goods happen to be destroyed. But ultimately, the banks deal in documents and nothing else. They are truly more important than the goods for the purposes of a letter of credit. And this is called the principle of independence or the principle of autonomy. I think the UK and Australia like the expression, the principle of autonomy. The documents used in documentary credits in international trade, well, there are many, but there's a commercial invoice, a bill of lading, or other relevant transport documents, whether it's a seaway bill, an airway bill, railway documents, maybe a certificate of inspection, maybe a maritime, which I see that I've spelled incorrectly, a maritime insurance certificate, export certificates to prove that the proper export fees have been paid, warehouse receipts, stock receipts, railway consignment notes. So, and it can be a huge number of documents, or it could be a small number of documents that a bank gets in to inspect. Now, the EUCP says some documents might be electronic and some might be paper-based. And sometimes the person, the beneficiary who is presenting the documents to the bank doesn't have a choice. Because if you go to, they go to their country and say, I want an export certificate proving that I've paid the export fee. Please give it to me electronically. And the government department goes, we don't do that. It's paper-based. Or the reverse could happen. Can you please give me a paper certificate? They might go, we don't do that. We only do it electronically. So the beneficiary is not necessarily in control of the type of documents that they will get. However, strong, robust, unified laws at the behest of UNCITRAL, and for example, put in place by countries like Singapore, will help give greater strength and stability to international trade if we can respect and use electronic documents more so. Perhaps even by the Chinese suggestion of having a transferable transport document. I find that intriguing and most exciting. After all, now we get to the model law of electronic transferable records, which has been beautifully summarized by Carl Way. It should provide confidence and trust, reducing risk, to be mutually acceptable by all parties. Many documentary issues are resolved by the model law of electronic commerce, the model law of electronic signatures, and the UN Convention. But the UN Convention deliberately said, you know what, there are some things that are tricky that we can't deal with now. So Article 2 of 2 says this convention does not apply to bills of exchange, promissory notes, consignment notes, bills of lading, warehouse receipts, and any transferable document or instrument that entitles the bearer or beneficiary to claim delivery of goods and the payment of the sum of money. Now, they said, we're going to do, that was in 2005. They said, we'll deal with it later. And they did that, they had that colloquium in 2011, and we started up the work on the model law of electronic transferable records, which we finished in 2016, 2017. I just want to give you these two quotes from the preamble. It's the preamble to the model law of electronic transferable records. Then I think I have one more slide. Considering the uncertainties as to the legal value of electronic transferable records constitutes an obstacle to international trade. Considering that that's a problem, we want to write this. Convinced that legal certainty and commercial predictability in electronic commerce will be enhanced by the harmonization of rules and legal recognition of electronic transferable records on a technology-neutral basis and according to functional equivalence approach. Now, that's the promise of the preamble, and I think the proof is in Articles 10, 11, 12, as referred to by Carl Way. He's already given you the definition of what is a transferable document or instrument, so I shouldn't need to repeat that, but it entitles the holder to claim performance of an obligation indicated on that document or instrument or to transfer that right. And Carl Way gave you some detail of how that occurs, but I simply will say that in the paper world, you possess a bearer document, for example, which gives you rights. And people who are conservative might go, I understand that. And how do you do that electronically? You call it exclusive control and define it by a reliability standard. And you also use a technology whereby only one can exist. Now, we don't refer to the technology in the model law or indeed in the Singapore Act, but it could be something like blockchain or distributed ledger technology. If you want to know more about that, if you look at the model law of electronic transferable records, there's a large explanatory note that does refer to technologies like distributed ledger technology. And of course, delivery of a bill of exchange, for example, is by delivery. I'm being a bit circular there. Transfer is by delivery, transfer of the title. Sometimes it's a physical thing. Maybe it's endorsement and delivery. And how do you physically transfer or deliver an electronic document? And that is, as Carl Way talked about, the transfer of control. One, possession is exclusive control and transfer of the exclusive control. So when I transfer it to you, I no longer have rights with regard to that instrument, which is what happens with a piece of paper. And so we get rid of the problem of copies of the instruments. And my last slide, for sure, banks are conservative in nature, so I have found in letters of credit, and they like to deal with pieces of paper the bank examiners are used to having certain documents, although some banks send it off to a central place for examination purposes. To get over that conservative nature of the documents that they have been used to is modern business practice, and it can be met by strong unified laws. And I think the model law of electronic, or I'm certain that the model law of electronic transferable records enhances the facilitation of international trade. And hopefully that leaves a little bit of time for question time. Thank you, Angela.
Thank you very much, Alan, for your presentation. And I also thank all the speakers for having kept within the time, which gives us now 10 minutes for discussion. My colleague, Thomas Trashler, invited the participants to send us their questions through the chat. But in the meantime, until we get the first questions through the chat, I would use also my prerogative as the moderator to ask each of the panelists one or two questions that occurred to me following their very interesting presentations. And first question I'd like to ask Kawei is, when you explained to us the Multimodal Act in Singapore, you quoted to us a provision that defines the use of an electronic transport document there as one using EDI, and we know that EDI is a particular technology, and that the UNCITRAL text and model on electronic transfer records is actually more generic than that. How would you see that the two provisions operating, and would you think that there is scope in our act that refers to EDI to give it a more technology neutral interpretation so as to cover also other means of electronic communication? Know that we define electronic communication in broader terms in the UNCITRAL instruments. I also have a question for you, Guo. I found your presentation also extremely interesting, and would appreciate perhaps if you could elaborate a little bit on your the concept you explained of modality neutral approach in a new instrument, in a way that would completely avoid any reference to liability. So far, our consideration of the scope for a new instrument on negotiable multimodal transfer documents was very much inspired by the FIATA model, bill of lading model, where you have some sort of an interface between that document and the unimodal documents. But your observations that bills of lading already perform a document of title function, which is in a way independent from the underlying liability regime, it's an intriguing one, and I'm sure that also that the participants would appreciate if you could spend some more time discussing that. And then the last question that I'd like to ask then Alan is, Alan, we know that, and we started by saying how far the banking and interpayment system is already dematerialized this day and age. We know that from the investment security sector, where this actually has been around for more than 40 years, and in many countries the law even prohibits the issuance of investment securities in certificated paper form. That has all worked very well within a closed environment, and in many cases has been based on registry systems, be it registry systems by the issuers or by the intermediaries, or some sort of a transparent top level registry systems, as for instance China has for securities trading. How would you see a wider use of electronic documents within the banking sector, in the documentary credit and letter of credit industry, consider that here we're talking about an open environment and not only one that is bound by a firm set of rules as would be securities trading. So with that, maybe then ask the three speakers to answer that. And before I pass to you the questions that are arriving in the chat. Kawei, please.
Thanks, Angelo, for the question. Well, the provision that I was referring to, I referred to it as an evidentiary provision. In fact, that I didn't show the first subsection of that provision, but it's about the multimodal transport document being evidence of what it contains, right? And for some reason, the framers of that treaty thought fit to address in the case of such a document being transmitted via EDI. Well, that treaty was concluded in 2005 by ASEAN and would have taken quite a number of years in its formulation. So it is apparent that the framers then, being negotiators of a transport document, a transport treaty, were not perhaps as up to date on the latest in the development of internet technologies as UNCITRAL was. So the UNCITRAL ECC was concluded in 2005 as well. So it's obvious that there was shall we say, a communication a gap there. But I don't see, in my personal view, I don't see that the mention of EDI is a significant obstacle because it's only an evidentiary provision. As I noted, the Act does not actually tell us how an electronic multimodal transport document is to be achieved. Right. So the provisions actually deal with the operator, the substantive aspects of it. So in my view, there is nothing stopping the Mlvtr, the enactment of the Mlvtr from being applied to electronize a negotiable multimodal transport document, assuming, and that's a big assumption, that it fulfills the definition of a transferable document instrument. Thank you.
Thank you very much. You?
Well, thank you for your question. I must admit that it is a very difficult question to deal with the relationship between the law of bill of lading and the law of carriage liability. At this stage, I just want to make 2 points. That is, firstly, it is possible to separate the law of bill of lading from the law of carriage of goods. One example is in England, we have bill of lading law, which was enacted in 1855, but they have different carriage of goods by sea law. And so I guess this is an evidence that the separation is possible. And the second point is the difference exists in the different modes of transportation will not necessarily affect the unification of the law of bill of lading. For example, for ocean bill of lading, actually there are 3 international conventions on carriage of goods by sea, but we use bill of lading as a document. And I think that's another evidence. Okay, thank you.
Thank you very much. Alan?
Yes, I trust you can see and hear me.
Yes.
I think your question talked about banking and closed environments and registry systems which exist. I think you said, how would you see the wider use in industry of this electronic environment? I have a great faith in what as a common law lawyer, I would refer to lex mercantoria, the law of the merchant. The concepts of bills of lading, bills of exchange, and indeed letters of credit were developed by merchants who didn't worry about what the law was, and there was no UN and no ICC, and just went about their day-to-day business of engaging in international trade and came up with solutions. I mean, I think the Bill of Exchange is a novel approach by putting in the concept of negotiability, which legislatures wouldn't have come up with, but the merchants did come up with. In other words, they try to find the best vehicle to suit their business and their transactions. But today we are locked in a little bit more with certain systems and approaches, and we follow the system rather than trying to find innovation. But I think we need to show the parties that innovation. I'm looking forward to tomorrow, where we have one of the founders of Bolero, for example. Bolero is a closed bill of exchange, electronic bill of exchange system, which was most exciting when it came out. But it is a central registry. It's referred back. You have to be a member. It's not necessarily transferable to other people who are not members. What's exciting about the model law of electronic transferable records is that there are sections, there are articles, which I don't think we've spoken about, which allows you to have an electronic record and convert it into a paper document, or have a paper bill of lading and convert it into an electronic document where the need arises. Because you might find somebody that you're trading with that says, we don't deal with the electronic documents, or we don't deal with paper documents, as you alluded to. I would see that as we educate, and as we the merchants and industries, and as we have countries like Singapore and Bahrain, and to a certain extent the United Arab Emirates, it will become more popular. Some of the great UN instruments, like the New York Convention, is very popular, but that goes back to 1958. The CISG is always up to 94 countries, but that started in 1980 or 1988. And I think we just need a few more years to go by to educate people that this is an open system that works. One final comment is that people have a slight mistrust about electronic commerce because they don't know what's really happening in the computers. But I have the reverse. I can see paper documents that are easily forged, whereas we know electronic digital signature systems that are, I'll use the word immutable, and we know that there are blockchains out there that really can give us great confidence in electronic commerce. We just have to get that message across in international trade, and the model law of electronic transferable records does that, or is doing that. I trust.
Thank you very much, Alan. We are running out of time, but I will pick up one question that we were asked by, we got through the chat, is a question to Kawei. And Kawei, it's a question concerning your enactment of the electronic transfer of records law. And the question is, Article 16Q speaks of accreditation of A, the provider of the ETR management system, and B, the ETR management system itself. Why both? Sub-question, is public blockchain contemplated in the latter, since there is no provider? Kawei, please.
Thanks, Angelo. It's a good question. Thank you for the question. That provision, well, I'll share my view as the drafter of that act. We referred to an accreditation of the system as well as of the registration, accreditation, etc. of the provider, because it is conceivable that a provider can have more than one system, right? So it has to be that system we are considering that supports the use of that particular ETR was vetted, as well as the provider. So both. I think it just requires both to have been vetted. That's the first part of the question. Angelo, the second part of the question
is public blockchain contemplated in the ETR management system?
Well, so this is my personal view. Yes, is the short answer. but it's a much more complicated answer than that. There are quite a number of, I'm aware of quite a number of projects under development by many parties using blockchain technology to implement electronic bills of lading. So the use of that technology is possible, right? It's basically a decentralized registry. Now, I think perhaps the question is implying that in a public blockchain, there's no provider. Now, I would question that assumption, because somebody has to put it together. Somebody has to ensure that it works as designed. Somebody has to make sure that if there are certain modifications that may be made subsequently, it continues to comply. And that's the role of the provider. The provider has to ensure compliance at the beginning, in the continued operation and till the end. So I would say even with a blockchain as this DLT as the form of technology, you still need a role of somebody who's supposed to ensure compliance.
Thank you very much, Harry. I suspect we'll continue that discussion tomorrow when we talk about the use of electronic replacements of bills of lading in the maritime sector, as since one of the providers, one of the speakers would also present to us a blockchain based negotiability system for bills of lading. There was one question also on the chat about the practical use and statistics on the use of negotiable multimodal transport documents or records were permitted. I suppose that we may get to that that question on tomorrow afternoon tomorrow, the second panel, when you talk about negotiability of negotiable transport documents. And the last question I got in the chat was whether the panelists believe that the use of electronic documents as an alternative to paper documents would not lead to optimizing the way information is gathered, compiled in these various documents, bill of lading, customs declarations, and so on. This is a question which actually would lead us straight to the next panel, and I would bear that question in mind to ask the speakers there. With that, we'll conclude the first panel. I believe that all the attendees will join me in thanking the speakers for their very useful, informative presentations. We will have a short break now, and we'll be reconvening here at 11:15. So a 12-minute break. Thank you. So, dear participants, welcome back, and welcome to the second panel of our webinar. We have again 3 speakers. I'll introduce them briefly. Each of them would have approximately the same time, so 15 to 20 minutes for their presentation, ideally more closer to 15. The first speaker will presenting to us the perspective of the International Chamber of Commerce, the ICC, on the issue of regulatory and industry responses to the dematerialization of trade documents. He's Oswald Keiler. He's the former head of data strategy of BHP, the world's largest diversified mining company. Has focused on providing solutions to enable electronic documentation records management, business process management, enhanced collaboration reporting. And within the ICC, he's focusing on further enabling trade digitization through the creation of international standards. The second speaker is Hans Huber, who is the PO Trade Finance DOT RD at the Commerzbank in Germany, has worked in Germany, Japan, and UK. is currently based in Frankfurt and works at the DLT lab of Commerzbank, leading the DLT Trade Finance Innovation Project. He has contributed to many projects at Commerzbank, and was one of the founders of the Commerzbank's DLT lab and oversaw the initiation of a variety of DLT-based activities within the bank. And last but not least, we have Jun Xu. She's the Deputy General Manager of Global Transaction Banking Department, the Bank of China, Jiangsu branch in China, with more than 28 years of experience in trade finance in domestic and overseas banks. She's a member of the ICC Banking Commission Executive Committee, the ICC Market Intelligence Team, ICC Global Survey of Trade Finance editorial teams, and several other gremia and commissions within the ICC. Also, as I said, we're presenting Digital Standards Initiative and the ICC perspective on that. Hence, we'll be presenting blockchain and other electronic processes for documentation and record in the banking sector, and the extent to which the existing legal framework already allows that, in particular in Germany. And Jun Xu would be presenting to us the Chinese perspective on the dematerialization of trade documents. So now, without further ado, Oswald, the floor is yours.
There we go. Thank you so much. Can you see my screen?
Yes, you can.
Okay, perfect. Thank you so much, everyone. Thank you for the opportunity to join you here today. My name is Oswald Kaler. I'm the Managing Director of the DSI Initiative. And I have to add something to the introductions. Hans Huber was also one of the instrumental members that were part of founding the ICC DSI. So it's really nice to talk first about the DSI and then be followed by Hans, which is fantastic. So I have a few slides for you today, and what I'm going to be focusing on is first taking you through a macro level view, both the impacts from last year at a high level, where we are this year, and then talk a little bit about the Digital Standards Initiative itself and what we will be advocating for, especially during 2021 at the ICC. So without further ado, firstly, when we have a look back at 2020, to say it was a challenging year is definitely an understatement. And the way in which, from a DSI perspective, we look at 2020 is fundamentally through these three prisms. Firstly, we had quite a big health and safety impact through the pandemic that's hit us. And beyond the personal impacts and the losses that people had, both from losing family members and also the impacts on jobs, it also impacted people's ability to actually go into the office and get access to the documentation and the information that they need to execute their work. The second thing that we also saw was quite a little bit of an uptick in the fraud-related events when it comes to trade finance, especially as people deal with physical documentation slowing down through the supply chains and a heavier reliance on LOIs than usual in this space. And then finally, trade disruptions. We've seen trade routes being disrupted through lockdowns of ports, etc. And through all of this in 2020, we've also seen a lot of executives, importers, exporters, carriers, having a look at the investments that they've already made in digitizing their trade and supply chain processes to see how does all of that existing investments actually help them take their business continuity plans and actually execute on them, actually move from physical to digital. And so when we think a little bit about that and we look at where we are today, again, let's think about those in three core areas. So firstly, we've seen a lot of those business continuity plans at importers, exporters, and carriers actually transition to digital, embracing new technologies. And when you have a look at some of the platforms that release information around membership and volumes, you can definitely see quite a bit of an uptake in the membership there. And so we've been fortunate to have platforms out there like I saw Paul Mullins on your Boleros, S-Stocks, R3s, all of these, where we could actually, as a business community, rely on the digitization of our processes. We've also seen a further increase in our capabilities around digitization. People are getting less confused around what blockchain does and what Bitcoin does, and are starting to have a stronger sense of how the various technologies can actually work together to enable trade digitization. Where does public blockchains fit in? Does that mean I don't have databases internally? All of these questions that we struggled with 2-3 years ago have started to transition to people now having more of the difficult conversations around the legal side. And how do we ensure not that the technology itself is ready, but rather that we have a true understanding of what it means to, for example, digitize title documents. If you transition back 2 years ago, not a lot of people would have been talking about, well, liability clauses, etc., in the business community, and we see that as being quite a big topic today. The final thing that I want to highlight from where we are today, both from an uptake in digitization and an increase in our capabilities, is also definitely a more united approach in solving digitization. If we go back 15 years ago, there was a view that digitizing trade is going to be done by 1 or 2 companies globally, and whoever wins will win, and all countries on earth will be using these platforms. And where we are today is we've seen a recognition that 1 or 2 platforms won't necessarily own everyone's digitization journeys, but rather that carriers, for example, want to be able to participate in preparation and issuance of their title documents. Importers and exporters really want to be able to step up and really start contributing to those sustainability goals, and the list goes on. So we're all united in our focus of how do we actually solve the digitization journey and how do we unlock it. And I think that is also fairly unique. We've seen the limitations of our approaches last year, and we're actively trying to solve through some of those. So what does that mean in practicality? And I'm gonna stay a little bit high level for my section because I know some of the people coming after me will go into a little bit more detail. But the bill of lading is something that was covered by previous people like Alan and them quite well. And it's the digitization of this specific document or documents of title that's definitely become quite a topic over the last few years. It's important because it's one of the key challenges that we have when it actually still comes to being able to digitize trade. In some of the less complex supply chain industries, for example, mining, we can see a lot of great successes over the last 12 to 24 months in the uptake of digitization, where it is possible to get your carrier, your importer, exporter, bank, and your whole supply chain onto a similar platform. But when you transition to other industries like retailers, it's a little bit more challenging. And a single data point really stands out for me. The DCSA, the Digital Container Shipping Alliance, released a number in December, 0.1%. The amount of electronic bills of lading being prepared and issued in electronic format today. And that shows us that we have a lot of room for growth when it actually comes to the utilization of digital documents as opposed to paper within this landscape. There's a few other elements that we've also recognized. The first is operating model embedment challenges. So we all understand that one platform is not fundamentally going to quote unquote rule them all, and that we need to operate in a landscape where different entities and different industries can select the platform of their choice. But when you look at, for example, the banking space, how do you enable that branch level employee to execute their task on that bill of lading in a way that mitigates risks for a bank and enables them to fully embed and integrate digital processes at scale at a branch level? And so there's a lot of questions around, well, how do you do that? Do you teach people how to leverage all of the different platforms out there, or is there a level of interoperability? Can someone sitting either at a carrier prepare and issue the negotiable document that they want to, and using whichever platform they prefer? Can an importer and exporter manage their trade processes, again, not necessarily using the same platform that the carriers might have enjoyed, but using something slightly different based on their use cases, but still being able to use that title document. And then finally, at a branch level, can they use EUCP, for example, to actually leverage the electronic versions of that on a practical level by being able to use whichever platform or technology of their choice to view those title documents. So that's quite important. The second one there is also, how do you enable this for especially low margin industries? So some industries, for example, mining again, even though it's a struggle, you can see organizations signing up to 2, 3, or 4 different platforms to enable paperless trade. But there are other industries and smaller players that can't actually go through that process of having multiple systems where they have to train up their staff on how to use the different systems, and they have to pay a licensing fee, and that all just to execute the same process. And so how do we create this level of interoperability where there's freedom of choice, where companies can actually use the systems? And then finally, how do we transition away from this conversation around, for every dollar invested, how much of our documentation that we are using in trade has been digitized, towards a future where that's no longer the conversation, because we can now start focusing on some of those higher level use cases around supply chain visibility. One could argue that our ability to unlock the Sustainable Development Goals are at the back of being able to digitize our documentation at scale and not necessarily relying on paper documentation. And so there's some key requirements to consider if we want to transition into that future. We've listed a few on this slide today, and it also gives you a little bit of a sense of where the DSI is focusing its efforts on solving for. So on the left-hand side, the situation today. A lot of, whether it's fintech platforms, importers, exporters, carriers, banks, there's not necessarily a full-blown recognition of what are all the standards that are already out there. A lot of people realize that standards is the key to interoperability, making sure that all of the different platforms have the same language when we actually talk about elements like legal entity, bills of lading, for whether it's for containers or whether it's for dry bulk, etc. Because if we know that the basics are the same, it becomes so much easier for us to integrate our solutions. But we need to ensure that those developers who are actually building the software, whether they're working at a fintech, whether they work at a bank, whether they work at a carrier, at least all know these are the foundational standards for trade. And so this is the first area where we really want to make an impact. How do we show everyone what are the foundational standards? The second one is outdated regulation, and this is very important for us. It's something where the ICC is really amplifying its ability to contribute. We know that standards are great for enabling efficiency, so it makes it quicker and cheaper for people to integrate and build systems. But we know that when we get to the effectiveness of that, so are we going from 0.1% trade digitization to, let's say, 50, relies on our ability to have functional equivalence for electronic transferable records. And so it's one of the key things that we are advocating for in multiple different jurisdictions. And you'll see us at a minimum providing some playbooks to our own business community. A lot of business partners want to know, how do we actually have that conversation? We understand now that there's a model law, we've heard about it, but how do we actually contribute into that process? So there's some work that we're going to do there to provide people with the ability to have that conversation, and we're going to accelerate our engagements globally. When the DSI started in September last year, only a single country leveraged Mlvtr. Where we are today, we're already at 3. And our hope is in the next 5 years that we can add an additional 5 countries into that at a minimum. And there's some really good progress being made there. Then there's the private law side. And this is quite a challenging environment. When we think, and I saw some of the questions a little bit earlier today around how do we solve for liability. The truth of the matter is that the P&I Club plays an important role. and being able to certify the rule books that the platforms use. And those rule books define how do people deal with title documents, and mostly in a centralized fashion, if you will. And so one of the key things that the ICC is going to do in that space is have a look at, is there a way for us to contribute in the space? What does that mean, both for countries that are Mltr enabled? How do we get the P&I club into that landscape so that we can actually ensure that the carriers, for example, know that this is what liability means in those jurisdictions? And then for those who are not yet Mltr compliant, how do we, or enabled, sorry, how do we solve for how title registries work? So there's a little bit of work that we need to do there. And the last two is really just the actual hard yards of standards work. So we're very proud to be working with quite a few different organizations, because our view is every industry will have different information that's specific to it, where that industry can actually go produce a standard that's fit for purpose for it, that can help trade digitalization. A very good recent example is the work that the DCSA, the Digital Container Shipping Alliance, have done in relation to democratizing the definition of preparing and issuing bills of lading for containers. And this is quite important. It means that whether you're an importer, exporter, or carrier, there's a open source, everyone can see view of what does preparation and issuance mean when it actually comes to e-bills. And there's quite a few additional standards in that landscape that we're going to be working on, again, with partners. And the final one there, costly technical integration. This is quite important. And I also saw some questions on public blockchains, which I found quite interesting. So how do we ensure that you don't have to necessarily be a big incumbent player to contribute into this processes? Today, if 2 or 3 platforms want to integrate, there's a R&D project, an integration project, some designs that needs to happen. How do we make that more efficient so that smaller players can pick up a bunch of standards and say, oh, this is the language for integration, and we can all contribute, again, whether I'm a small fintech or whether I'm an importer and exporter that just wants to update my own sales operation systems to actually deal with these type of documentation. The final point there is when we think about the technical standards, there's also areas there where we do need to think about some frameworks, legal frameworks as an example, that can actually enable distributed title management. And this is where, for example, the trade trust framework that the IMDA has been working on is definitely something that we're busy reviewing and looking into. Is that a mechanism for us to democratize the title process? So the final slide that I have, and I wanted to keep it simple, is just giving you a sense of, so what are some of the standards that we are advocating for? And the very core, you'll see Mltr. It's foundational. It's at the core to every conversation that I have. Again, while standards are great because they'll make it more efficient for companies to integrate, the reality is we need countries to adopt the model law from UNCITRAL for electronic transferable records. We need functional equivalency in more countries, more jurisdictions, and we're going to keep on pushing for that. There's also a bunch of ICC products that we have. So we have EUCP. And so working again with the banks to understand, how do we ensure that this is something that can be workable and at a branch level, so that the felt experience when they use electronic versions of documentation is practical, and we can see that being used. You'll see a few other items there. The DCSA we touched on a little bit earlier with their EBL standard for containers. There will be a few more container standards coming out in the next few months that I'm also quite excited about, but can't talk about yet today. There's ISO standards, foundational standards that people can use. And then the LEI, and specifically the GLIFE enablement of legal entity identifiers globally. So that is my presentation for today. If I leave you with anything out of the presentation that I just gave you, it would definitely be that we need more advocacy when it actually comes to the adoption of Mltr from a business community perspective, we want to enable carriers to prepare and issue bills of lading. We want to enable importers and exporters to leverage that documentation in a practical manner, and for branches to be able to use EUCP at the banks and use electronic presentation files. At its core, Mlvtr is going to help us with that because it will enable functional equivalency. And around that are all of these foundational standards, legal entity, electronic bills of lading, etc. That's going to just make it so much more efficient for us all to do. Thank you for your time. And I really, again, appreciate the invitation. Thank you.
Thank you very much, Oswald. And obviously coming from UNCITRAL, we're very grateful for your forceful advocacy in support of the adoption of the model law, which actually now makes a very good transition, I think, to the next presentation by Hans, because he will begin exactly looking at it from that angle, what is out there in the terms of legal framework, but then what in practice banks are still experiencing as perceived obstacles or reluctance to fully embrace the digitalization of trade documents. Now, thank you again, Oswald. Now, Hans, the floor is yours.
Thank you very much, Jose, for that introduction, and thanks a lot, Oswald, for preparing what I have to say now. I'm missing my presentation. Is that going to be fed in by me, or will that be fed in by you? If you are not feeding it in, and I'll share my screen. Give me a second, please.
Yes, please go ahead and share your screen, please.
All right. Okay. So here we go. I hope you can see my screen now. If you could please confirm that, then I'd be
yes, we can.
Happy. Great. So thanks a lot for that introduction. And Oswald has highlighted very spot on what is required in order to allow for all of us to replace documents with electronic records. And we have sensed this need already a long time ago. And we have in Commerzbank, the company for which I work, which is Germany's second largest bank and has around a 30% market share in trade finance in Germany. We have sensed this requirement for a long time, and therefore have built up technology labs in our company in order to do research in what is required and how we will have to change our business in the coming years in order to remain in business when the document will hopefully be disappearing. We have contributed to a number of DLT-based endeavors, namely in the trade finance space. It was Batavia, and we are still active in the Marco Polo project or program. And while doing that, we have seen that there is a lot of interoperability needs, not only on a technical level, but also on a legal level required. And that is why we have also helped to raise an initiative that is now called the ICC DSI. And we're very grateful that Oswald Keiler took it over and is putting a lot of energy in it to propel trade digitalization. Now, I don't want to talk about all this blockchain and AI and IoT things that usually people talk about, but I want to shed a light on the legal situation of Mlvtr in Germany for a change. And we believe that Germany is halfway, or in essence, Mlvtr compliant already, and it has been for the bills of or for the negotiable instruments ever since in 2013 our commercial code was amended and adapted, and this in our opinion has been performed very closely to the Rotterdam rules. The Rotterdam rules seem to have been, with the assertion of functional equivalence, a role model for the German legislation changes on documents of title. So we are very close to the first, what I call axiom of the Mlvtr, which is the functional equivalence to the existing instruments. We hope that the DSI and other standardization endeavors will allow us to come closer to singularity of records across the multitude of systems that the world will see. So a singularity of a record would be in a dream would be that there is only one bill of lading, for instance, for any given transaction in a trade relation, and this bill of lading would exist exactly in one system that everybody who's using it refers to and can access. And this person or the collective of people around that transaction would then assume exclusive control of the information objects that this bill of lading or a letter of credit or whatever else is represented by. As I said already, it looks to us that Germany is mostly Mlvtr compliant already. So I'm not going to bore you with all the legislative text, but I'd like to show them to you in a quick run through. And as you can see, I have listed these papers, and the color actually mean a status. So we believe that we are compliant for bill of ladings, warehouse receipts, and inland waterway consignment bills. And we may need to do a bit of work with our legislators on the certificate of transport insurance, the bill of exchange, and the promissory notes. And for the consignment notes, it appears that Germany is already compliant to the functional equivalence assertion of the Mlvtr. Let's have a look at the bill of lading. And as I said, I'm not going to bore you with all these texts, but it's worthwhile reading through the section that rules the bill of lading in Germany. And in paragraph 2, it says, an electronic record having the same functions as a bill of lading shall be deemed equivalent to a bill of lading, provided that the authenticity and integrity of the record are assured. And that's an electronic bill of lading. Now, in paragraph 3, it empowers the Federal Ministry of Justice and Consumer Protection to determine by regulation issued in agreement with the Federal Ministry of the Interior and not requiring the consent of the Federal Council, the details of issuing, presenting, returning, and transmitting an electronic bill of lading, as well as the particulars of the process of posting retroactive entries to an electronic bill of lading. That, in essence, means that legal ordinance can be issued by those two ministries detailing out the functional equivalence of a bill of lading rendered in electronic form. That is just the only thing still outstanding. Now, let's continue to the warehouse receipt. The text is almost the same. It's more or less functionally equivalent, and I won't read it out to you again. The consignment bill for the inland waterway bill of lading, same thing, regulated in the German Commercial Code, and functional equivalence is asserted. What is missing in the German law is the transport insurance certificate. It is mentioned that it can be transferred by endorsement if it is being made out of order, not out of order, or made out to order. There is a clear section missing on the transport insurance certificate, and that needs a bit of clarification, but it can be assumed that the same functional equivalence assertions will be applied to the transport insurance certificate. Now, let's go away from the documents of title and see what the German law rules for consignment notes. And this is the general consignment note sections, which will cover road, railway, and airway bill. And there also functional equivalence to the paper instrument is asserted. So we're safe on that, it appears. The seaway bill has an own section in the German law, and to bore you with the same details, it is also possible to be rendered in electronic format as long as functional equivalence is made sure. Let's go to the bill of exchange and the promissory note in the German law. Now, the Bill of Exchange Act, the Deutsche Wechselgesetz, asserts there to be a so-called Urkunde, which is an instrument or a document, a piece of paper. However, the more general law, which is the German Civil Code, which is closely related to the Commercial Code, says that an instrument does not really need to be, does not really need to be in written form. It can also be rendered electronically unless the law prescribes else how or otherwise, which we were not able to find for the Bill of Exchange and the promissory note. So promissory notes and bills of exchange seem to be able to be rendered electronically as well. However, that needs a bit of clarification. So, bottom line, it appears that Germany is and has been Mltr compliant in essence ever since 2013, at least for the most important bills of negotiable instruments, and there is little work else to do in order to render it fully Mltr compliant, which I believe is good news, and it has been like that ever since 2013. Now, people may wonder why that has not been made use of and why there has not been more activity in digitalizing these papers, but the reason may be very simple and striking. This is a phone. As long as I am the only one to have a phone, it is not of much use. As soon as somebody else has a phone, it becomes a lot more useful, and it's really the best if everybody has a phone. So we really appreciate Singapore's electronic transferable acts, and we really appreciate other activities that we can now spot in order to make the Mltr recognized and ratified by more jurisdictions. Now, let's go to the benefits for banks that would come if we have a fully dematerialized trade administration. In other words, what happens or what can be the benefits for banks once documents have been removed or replaced by electronic records? We see a lot of streamlining for financial, streamlining potential for financial products administration. That means the administration of these products will become a lot easier and probably cheaper and faster. And so we'd be in a position to service more MSMEs, so smaller companies, a lot better. We could think about a complete set of new products and services through the parallelization and streamlining of processes. Think about what a bank could do if it was involved at the very beginning of the drafting process of a bill of lading. We could even consult our customers in how this instrument would need to be drafted in order to make it completely hassle-free in the presentation of a letter of credit that we are issuing. That is just one example of a completely new product that we could offer. All the sustainability assertions will become a lot more plausible and a lot easier to verify once digital records are favored over paper that is stamped and signed by someone in another part of the world that we probably don't know and cannot really scrutinize. Complicating fraud scams will be a positive result of us working entirely digital. We could support all the new technologies because they all require data to be available to us. AI doesn't run without data. DLT gives us the chance to put information on shared databases that we can trust. And IoT devices will feed into these databases that we share. So there's a lot to gain. And let me end this list of potential gains with the possibility to factor out services like KYC or AML checks that the banks have to perform as a consequence of regulation. I think factoring that out could make this service a lot better, a lot cheaper, and a lot more reliable. But we also have challenges. There will be high investments to be made into innovation, and the high pace of this technology progress will probably render some of these investments sunk, yeah? And that leads to hesitance today. The legal harmonization, which is required to use electronic records, is a lengthy process, and it needs to run on a global level. And Oswald has quoted that as well. That may not always be easy because there are deviating interests, and the technical standardization that is required is also a very broad field, and a lot of people have to contribute to it. So the challenges are high and numerous, but we see that common work on a communal layer for trade digitalization has started. And so we're very grateful to see that the ICC has taken over and founded the DSI and employed Oswald, who is running that with a lot of energy. Thank you very much.
Thank you very much, Hans, for your presentation, which is both very comprehensive and very thought-provoking. I have myself a number of questions that I would like to ask you after we hear the next speaker, and as I guess also the other participants would also have written down their questions. But now, without further ado, I invite now Jun Shu to make her presentation. And I say that you already, your screen is working, and the floor is yours.
Thank you very much. It is my greatest pleasure to be invited to share digitalization in trade finance from the perspective of practitioner in China. And my presentation will cover two aspects. The first one is the global digitalization trade finance trends, and the second is the that practice in China. Over the years, we have seen the rapid growing demands for digitalization in trade finance globally. The pressure on trade finance to digitalize has accelerated since the breakout of COVID-19. However, laws and regulations on electronic transferable records or other e-trade documents lag behind the market evolution and demands. And actually, I really find the panelist speeches very interesting and exciting and encouraging. And especially, I would like to congratulate on Singapore's achievements in the act, taking to adopt the MLvtr into their domestic legislation. And but the substantial progress is still limited, either from aspects of laws and regulations, security concerns, and other factors, such as the lack of uniform rules and standards, just as mentioned by other panelists. And ICC has been following closely the digitalization progress in trade finance industry and has set this digitalization as one of the major contents in its flagship publication, Global Trade Finance Survey, in recent years. Last year, the survey found out that for most trade documentation, over 50% of banks mentioned that the documentation was no longer mandated to be paper-based in the context of trade finance. Trade finance transactions are still heavily paper-based, which is very time-consuming and easy to make human errors. ICC 2020 survey finds out that of the 10 documents type looked in the survey, there were 4. If we look at this, there were 4 where more than 50% of banks replied that they must be issued in paper form, which are bill of ladings, promissory notes, bill of exchange, and certificates of origin. The figure reveals the inconsistency across different legal jurisdictions, which is one of the major obstacles in adopting widely digital solutions in trade and trade finance. More than $4 billion worth of goods are transported each year, and more than 80% of the goods used by consumer goods are transported by sea. The transaction document cost required to process and manage the transportation of core goods is expected to be up to 1/5 of the actual transaction cost. However, in 2018, ICC found out that only 24% of banks reported using electronic bills or other electronic documentation. A lack of unanimous e-rules or e-laws on BL is one of the major barriers. ICC also finds out that digitalization strategies in trade finance differ in various types of banks. Global banks tend to be more proactive. The major obstacles for implementing digital trade are the efforts and costs in upgrading banks' technologies. Among the various digital tools or solutions, the most common digital trade technology implemented by banks is the online platform for trade finance. 50% of banks have developed such platform, but only 20% of banks have developed the platform for EBL and other e-documents. And ICC in its 2020 survey found out most banks have removed the use of physical paper for documentary transactions to some extent. The use of a physical paper is more common among global banks. However, between half and 2/3 of local banks indicated that client usage of digital channels across trade finance products is either minimal or non-existent. For global banks, the number is close to 1/3. Most banks receive only a small amount, below 10% of documentary trade and open account trade transactions digitally. Very few banks have managed to create a fully digital zero-touch end-to-end process. Despite of the advantages of digitalization, digitalized trade faces constraints to wider adoption. Concerns about technical risks, including frauds, data security issues, and inoperativeness among new trade platforms, and also the recognition of the legal standard status have become a consistent issue. ICC found out that for banks that are finding that it's hard to implement technologies and digital solutions, 61% cited the challenges of building internal capabilities, and 51% consider that both regulation and client needs were hampering wide-scale adoption of digital solutions. To overcome these barriers, ICC has been actively promoting the development of digitalization in trade and trade finance, and made e-compatible rules and e-rules. ICC is currently in the process of developing a high-level framework for rules and obligation, URDTT, covering the use of electronic records to process digital trade transactions. There is no conflict between ICC rules such as EUCP and UNCITRAL's model law, including Mlvtr and the model law on electronic signatures. And just give the example of EUCP definition about electronic record and the electronic signature. ICC has also issued a series of guidance paper, and ICC digital route map promoting digitalization, called for supporting policies and laws from governments and the regulators, set up a working group on digitalization in trade finance in 2017, and started its ICC DSI program it's introduced by Mr. Kula. ICC also sent its memo to governments in last year, and that memo is to governments and the central banks on essential steps to safeguard trade finance operations. In the memo, ICC specifically calls for the adoption of UNCITRAL Mlvtr by governments. I would say that we welcome UNCITRAL's decision in developing negotiable multimodal transport documents from the perspective of trade finance practitioner in China. In practice, trade banks or ICC rules, such as UCP 600, accept different kinds of transport documents. When providing trade finance to clients, banks will adopt various types of collaterals, including the pledge of negotiable transport documents. In addition to other collaterals, trade finance transactions covering negotiable transport documents may give banks more comfort and a further choice of risk mitigation measures when things go wrong. For example, in China, a court case decided in 2015 by the Supreme People's Court of China was welcomed by the banking industry in the country for the cost protection of financing bank holding the original BL as a pledge. The court considered that the issuing bank and of the LC had its rights in the pledged bill of lading and recognized the issuing bank's priority right to be repaid. However, with the development of digitalization in trade finance, especially in EBL, banks in China wish that international and national laws and regulations on such aspects could be developed to facilitate trade and trade finance, since we are facing a completely different environment from the paper world. So next, let me briefly introduce the digitalization trade finance practice in China. In recent years, banks in China have closely focused on digitalization in the field of trade finance. We have seen digital solutions in the areas of settlement, financing, guarantee, risk controls, and compliance. In the area of transport documents digitalization, we have seen reports about the digitalization progress in railway, air shipment, and route transportation. And I read from the news that the National Administration of Railway of China has been promoting the digitalization of cargo shipment documents. And in 2019, a blockchain railway transport document was issued for shipment from Europe to China. However, in trade finance, we have not seen railway transport documents or airway bill or route in electronic form. But we do have experience of processing electronic bill of lading in trade finance. In traditional paper trade documents, flows in LC transaction, major disadvantages include inefficiency, high error rate, difficulty in timely modification of documents, and invisibility of the whole trade circulation processes. And the invisibility is one of the biggest pain points for trade banks, since it is the reason of many trade frauds. Banks are not a part of the underlying transaction and do not get involved in the production and shipping process. Therefore, it's not easy for banks to detect fake trades, forged documents, and duplicate financing by unfaithful clients. And the recent case of an Asian top oil trader in Singapore is exactly a good example of such problem faced by trade banks. The company created fake trade transactions and obtained duplicate financing from about 23 banks with a debt of over $3.85 million US. And the case was really astonishing, and it has created a shockwave among banks that some major banks even withdrew from the trade and commodity market. And some experts expressed the view that digital solutions such as blockchain bill of lading may help mitigate such risks due to the advantage of that technology. Digital bill of ladings, however, are not very common at this time in the trade finance business. Now let me briefly introduce 3 digital approaches adopted by banks in order to expedite the trade finance procedures involving bill of lading. Let's look at the scenario 1. Documents are in the form of a scanned, faxed, or emailed form. This kind of scenario is not common, usually happening under the contingent circumstances. For example, when paper documents transmission was interrupted due to the lockdown in some countries during COVID-19. In practice, due to the barriers mentioned just now, most of the LCs are not subject to EUCP and still require paper documents. ICC therefore provides possible alternative digital solutions for transaction setup before COVID-19 requiring paper documents is guidance paper issued last year on the impact of COVID-19 on trade finance transactions issued subject to ICC rule. As a bank in China, we successfully processed several LC transactions for our clients after the issuance of such guidance. And this is just one example of our SME client who exported goods to the importer in India, applying the guidance suggested measures. Due to the lockdown of India last year, the courier service was interrupted and documents were unable to be presented to the issuing bank timely. We suggested our client contact importer and discuss the possibility of accepting scanned the documents emailed by us to the issuing bank. Both the importer, exporter, and the issuing bank agreed with such agreements, and the issuing bank notified us their email address by SWIFT. We emailed the scanned documents with a SWIFT confirmation to the issuing bank, and the issuing bank then made payment after examining the scanned documents, including scanned bill of lading, and determined that documents were compliant. However, the difficult part is the delivery of the goods. The consignee still required the original BL in paper form to take delivery of the goods, but the applicant was unable to get the paper documents timely due to the interruption of the mails. So to facilitate the trade transactions, special arrangements have to be made. Usually there are two kinds of methods. The first method is upon receipt of the payment, beneficiary, the exporter, authorize the issuing bank, authorize the shipping carrier to release cargo to the applicant. However, it's not easy for the importer and exporter to compromise on such a decision, whether to release cargo first or make payment first. Usually the importer wishes to get cargo first and pay later, and for the beneficiary, vice versa. For LC beneficiary, if they request the carrier to release cargo to consignee without original bill of lading, they have to provide sufficient guarantee collateral to the carrier. While in reality, many of the exporters are SMEs and are unable to satisfy the carrier's such requirements. If the importer requests the carrier to release cargo against their shipping guarantee, they would equally be required to provide sufficient guarantee or collateral. And if the carrier requires such shipping guarantee issued by a bank, the applicant would also have to have sufficient credit facilities or other collaterals with the bank. Next, I would like to introduce another scenario where banks and related parties use a third-party platform as a digital solution for SC issued subject to EUCP. In this scenario, the concerned parties, including issuing bank, carrier, applicant, beneficiary, presenting bank, they will sign agreements with the third-party platform, and the third-party platform would authorize concerned parties to get access to its system and transmit documents electronically. And the e-documents may be in scanned form, scanned PDF form, or data record, depending on the requirements of the third-party platform and their structure. Bolero and SDocs are the pioneers in this regard, and we have experience of using their services. And for example, in 2013, we cooperated with the UK Bank using Bolero's internet-based platform for electronic documents presentation. The physical endorsement on the back of the original paper bill of lading is done separately in the EBL system. Bolero's platform allows for transfer of title of the goods through rights registration function. And a bank as the holder of the Bolero's EBL may designate itself as the holder. If a BL is issued to order, the bank may transfer ownership of EBL on the platform and then release the documents to the applicant. This kind of digital solution may expedite the transaction process from 15 days to 1 or 2 days. However, it is not easy to persuade clients, especially importers, to adopt this digital solution, since they usually do not see much benefits in paying so fast. Only those who care much for price fluctuation and foreign exchange fluctuations are interested in issuing ELCs. For example, commodity clients. And the last scenario I would introduce is carrier issued EBL through using their own blockchain platform. Last year, a Chinese company, shipping company, what's called, developed its own blockchain EBL. According to them, the speed for releasing cargo has been accelerated from 4 days to 4 hours. It's quite amazing. And the EBL is structured data. After the issuance of blockchain EBL, the carrier sends shipper an email notice, and the shipper then may review the original EBL and request correction if there any online. And the shipper may download the copy of EBL, but they cannot download the original one. If correct, and the shipper then transmit the EBL to presenting bank. Once the EBL is issued, the whole flows of the documents, cargo, movements, and the funds are visible to all parties concerned. The issuing bank releases the EBL to the consignee when determining the documents are compliant and making payment after that. If endorsement of the EBL is required, then when the EBL is consigned to order of shipper or issuing bank, the shipper or issuing bank may log in the system and complete the transfer process. And the consignee may surrender original BL in the system upon receipt of the notice of arrival of goods from the shipping company, and does not need to go to the carrier's counter to submit the paper BL for delivery of goods. And the advantage of blockchain trade finance is its visibility in the whole trade life cycle with multiple parties sharing information and the paperless process. However, some documents, for example, inspection certificate or certificate of origin issued by authorities in paper form is still required. Therefore, the entire digital operation in trade finance will take time, because the successful digital operation requires the logistics, customers, inspection, and the other system to conduct a full range of electronic collaborative cooperation, and also the support of laws and different jurisdictions. Well, that is my presentation. Thank you very much for your attention. Thank you.
Thank you very much, Junshu. I think it was everybody, the attendees would agree with me that this was a very complete and very useful presentation, also of their banking practice in China as regards the use of electronic equivalents of bills of lading. And I'm certain that this will be very good to stimulate the discussion that we have now. What I would suggest that we do in the next 10 minutes, I have a few questions that have been asked through the chat, and then I'll add a few questions of my own in the meantime as I wait for more questions. One question that was, also I have also to apologize on behalf of Oswald Kyler. He had another engagement exactly now at 12:20, so he's not available for questions. But if anyone asks questions to him, I would be then happy then to transmit them to him by email and then obtain his reply later on. Now, as I said, I have a few questions. The first question I have here is for Hans, and I read out the question. The question is from Koji Takahashi. you said Germany is already halfway complying with the model law on electronic transfer records. What is the other half which is not yet complied with? And I may add to that question two more questions of my own. You refer to the standards now in the German Commercial Code for transfer documents and documents of title generally concerning integrity and authenticity. I understand that are there regulations issued to clarify what those standards are under German law? I'm not so sure. And if so, how does that relate to identity authentication under EIDAS, the European framework, legislative framework for identity management? And also, would a transfer document issued in electronic form in another country that uses a different authentication system that is not an advanced, for instance, signature system, would also be given legal effect in Germany? So these are the two questions that I have to you for the moment before I ask Shu a few questions, waiting for questions from the floor. Hans, please.
Yes, thank you very much. Let me first get back to your question about which half is not Mlvtr compliant. Well, I have outlined that in the presentation. We have looked at the documents of title, but we're not really sure about the bill of exchange and the promissory note. And our commercial code is also not really explicit when it comes to the transport insurance certificate. So there are a couple of gaps which still need to be filled, but it appears that it's not that we have to start from scratch, but we have already a very clear role model when you look at the bill of lading or you look at the warehouse receipt. So we don't have to start from scratch. And I believe it's not the other half that we're talking about. It's probably the remaining 15%. And you can also look at other trade documentations. Look at packing lists, look at invoices, look at certificates of origin, where the law is not as explicit and regulations may be spread among very many different laws and legal ordinance. So it requires a bit of scrutiny on the details here. Let me go to the other part of your question, which concerns integrity and authenticity of records being made. And this is very close to digital identities. You can imagine that we will not be having documents in future, and we will also not be having paper substitutes like PDFs. People who believe that PDF is a form of digitalization have to let down. It's just quarter digitalization. You can then transmit paper via email. That's all. The goal is to have things or have documentation put on systems that we rely on. And in the example of a bill of lading, we would have a probably DLT-based system that is tamper-proof and on which a bill of lading is a data set that I can only alter and modify in cooperation with the stakeholders around it. So you could imagine you have a DLT-based system with 100 nodes, and around that bill of lading, there are the stakeholders, seller, buyer, logistics service provider, two banks in a letter of credit transaction, and probably customs. And once you want to change that, modify that bill of lading, all of these stakeholders would need to consent to that, and they would use their digital identity and the verifiable claim that they are part of that transaction in order to effect these changes. So it's a bit like if I try to immigrate to Singapore, I get out of the plane and I'm being asked to prove that I'm vaccinated against COVID, which I could do using my digital identity, in which a verifiable credential is registered, which is signed by an authority in Germany who has vaccinated me. The same could apply to a bill of lading where an issuing logistics service provider has been given the right to write a verifiable credential into my identity because I work for Commerzbank in a trade relation that we have issued a letter of credit for. So that's the role of the digital identity systems, and they have to adhere to certain standards. Oswald showed us one authority or one body that makes these standards. It's the W3C, who is making the decentralized identity standard and is also making the verifiable credential standard. And these systems set up properly and following the assertions of the eIDAS regulation in Germany, in Europe, in our view, are sufficient to authenticate against the system and write entries into systems that would fulfill the requirements of the German law. So it is about building these systems properly and compliant to the law.
Okay, but I mean, no regulations have been issued so far as I understand under paragraph 443(3) of the German Commercial Code, right? Because I mean, there's supposed to be standards set by regulation for meeting the requirements of authenticity and integrity as provided under German law, right?
Exactly.
But there are no regulations yet. So this may be perhaps part of the other half that is not yet fully compliant.
Exactly. It's the legal ordinance that has to be thought through and written.
All right.
I wouldn't call it the half. I would call it the remaining 15%. It's all relative.
Okay. Okay. Thank you. It's just that the interoperability, as you know, then becomes a big issue when you get to then those nitty-gritty details. We have only 1 minute left, and I would like to ask Zhenshu 2 questions. The first is, how do you see the interoperability of, so you presented 3 models, and admittedly the first model actually we're talking about basically scanned copies of paper documents and not really true electronic ones, as Hans has pointed out to us. But the other 2 models are electronic. One is the last one is a BLT based, and the other one you mentioned the example of Bolero. How do you see issues of interoperability when it comes to the transmission of the bills of lading between participants of 2 different systems? And related to that, the other question I'd like to ask you is, how much scope do you see for negotiability of goods in transit in the context of this initiative to develop negotiable multimodal transport documents? You know, especially bearing in mind the Euro-Asian trade and carriage corridors, I mean, mainly road and rail. Thank you.
Thank you for the questions, which are very challenging for me. And well, for the first question, the second scenario I introduced actually happened before the blockchain bill of lading I invented, and we at that time we have two different kinds of approaches. For example, for Bolero, they do not require you to have the API connected, the system connected. So it's sometimes it's kind of easier for us to participate in that system. We go to the website of Bolero's system, and then all the other parties can also have their user ID and login in the system. So we do not have to make our internal IT, updates, something like that. So that kind of arrangements will not have any interoperative issues. However, for some platforms, we have to have our system connected with that providers, e-bill provider system. So if there are many e-bill providers, we have to set up a different kind of interfaces. So that's kind of expensive and cost, it's not efficient. And also for the blockchain, the advantages is very obvious. However, still there are limitations because we do not have the open, the open blockchain like a Bitcoin. We have to set up a consortium with the carrier, the bank, and the customers. And so these fragments of platforms are really a big challenge for unified electronic documents, especially the transport documents promotion. And that's my answer to the first question. And the second question, actually today's webinar is very encouraging. And after I listened to the panelist introduction about the development of laws in electronic transferable records, and I have hope in that aspect, and I wish that all the countries could cooperate in that aspect. So we will have I wish that in the near future we could realize the digital transactions in trade finance. Actually, in ICC's 2020 global survey, we also had that kind of questions, and some of them estimated that the full digital transaction could be done by 2025. So a couple of years to go, at least.
Thank you very much. Well, our own project also would take a couple of years to materialize. That international negotiations are not don't come to a result very fast. But I think we're also as encouraged as you are about what we've heard today. By way of conclusion of today's presentations, and I think everybody would also agree with me that they've been very informative, and that they have presented to us a wide diversity of aspects and facets of this phenomenon that we need to look at, beginning with the importance of a favorable framework for electronic transferable records through domestic implementation of standards such as the model law. But we know that when you get to international carriage of goods and international financing, only domestic implementation may not suffice. And and that would are likely to have to develop an international framework for that. I'm not talking now about the substantive aspects, for instance, the liability regime of any of that, but only for the electronic environment. We do have issues of interoperability that one would need to look at, as they tend to be regulated differently in different jurisdictions. But what I seem to gather from most of the presentations made is that even if we develop a system that would accommodate both registry-based and other types of issuance of mechanisms for issuing and dealing in electronic transferable records, that at the end of the day would always be relying on some system rules that the parties would abide at. And I think Jean Shu made this very clear in her presentation. And that in a way eases a little bit the task of the legislator for setting standards, to the extent that the legislator would then be able to rely on industry standards that would be recognized by the parties, and then sometimes by some important third parties, such as in the maritime sector, the P&I clubs. We'll be hearing more about that tomorrow. I would like now to, as we've come close to the end of the of today's panel, to the time allocated for today, I thank again all the speakers for the wonderful presentations. I'm sure they all get a round of virtual applause. And I look forward to welcome you all tomorrow for the third panel at 9:30 again. Thank you very much. And today's session is closed.